What is your initial inquiry when a prospective client approaches you? Traditionally, real estate professionals recognize their responsibility to ascertain whether a seller was under an exclusive listing agreement. When a seller contacted a licensee to discuss listing their property, it was understood that the licensee had the obligation to inquire directly or use available resources to confirm if the property was exclusively listed with another licensee. If there was an existing exclusive listing, the licensee refrained from requesting the seller to sign another active listing, as it could potentially expose the seller to the liability of paying two commissions. Irrespective of the listing agreement type, whether exclusive agency, EA, or exclusive right, ER, both were considered exclusive agreements, necessitating licensees to establish this fact. Remember that when using the EA, the seller could sell the property without you leaving you no commission received. Always use the ER. Similarly, for an extended period, when a potential buyer approached through various channels such as phone calls, emails, or during open houses, a common question prevailed. Are you currently working with another licensee, or agent, broker, or realtor? The buyer's response dictated the course of action. If the answer was affirmative, the buyer might have been advised to contact their existing agent. If the response was negative, the process would proceed, and properties or houses could be shown. In 2004, the National Association of Realtors, NAR, amended the Code of Ethics to include the obligation of determining whether a buyer is bound by a current, valid, exclusive agreement. Previously, the Code of Ethics had mandated the determination of exclusive listing agreements for sellers. Now, there exists an additional obligation to establish if a buyer has entered into an exclusive buyer-broker agreement with another licensee. Consequently, when a potential buyer-client visits an open house, it is imperative to ask early in the conversation, are you bound by a current, valid, exclusive agreement with another licensee? Rather than simply inquiring, are you working with another licensee? The latter question is deemed insufficient, as there is a substantial distinction between working with any licensee and working exclusively with one. A buyer who has merely signed a standard agreement with another agent would be considered as working with an agent. In contrast, a buyer who has signed an exclusive buyer-broker agreement has a significantly different relationship with that agent. If you do not have a buyer-broker agreement, you may not be receiving a commission. Here is an example. Issue: the broker is representing the buyer and has shown the buyer numerous homes over several weeks. One home, which was not on MLS, was shown to the buyer. The buyer then directs his sister, a licensed real estate broker, to write an offer on this home, and the transaction closes. Is the broker that showed the buyer this home entitled to a commission from the buyer? Answer: no. Under the statute of frauds, a buyer's broker must have a written employment agreement with the buyer in order to be paid a commission by the buyer. See ARS, paragraph 44-1017. Note: no written agreement is required between brokers for the payment of a commission, e.g., if the listing broker tells a buyer's broker that I will pay you a 5% commission if you find me a buyer, and the buyer's broker finds a buyer, the listing broker will owe the buyer's broker a 5% commission. Similarly, verbal amendments to a co-broke commission agreement between brokers are enforceable, e.g., if the MLS says 4%, and the listing broker states to the buyer's broker that I will pay you 5%, not 4%. The buyer's broker will be entitled to a 5% commission if a buyer is produced. But such an agreement should be in writing to avoid disputes. Arizona Realtor R. Digest. November 2008. Even if the buyer signed the agreement, what if the buyer's agent did not? The buyers manually signed a buyer-broker employment agreement, but the buyer's broker did not. Is the agreement enforceable? The Arizona Court of Appeals recently answered this question in Young vs. Rose, number 1 CACV, 100786, September 25, 2012. For several years, a buyer's broker worked with the buyers to find a home in the $4 million price range. During that time, the parties entered into several buyer-broker employment agreements. In January 2009, the buyer's broker emailed the buyers a new agreement. The buyers printed the agreement, signed it, and emailed it back. The buyer's broker responded, "Thank you," via email, with a signature block containing the broker's name and photo. During the term of the 2009 agreement, the buyers purchased a home using another real estate agent. Thereafter, the original buyer's broker sued the buyers for breach of contract, seeking to recover the commission set forth in the agreement. The court ruled that the agreement was unenforceable without the buyer's broker's signature. The court held that a real estate broker may sue to recover compensation due under a real estate employment agreement only if there is a written agreement that complies with both the Statute of Frauds, ARS, Par 44-1017, which requires a written signature of the party to be charged, and the Real Estate Employment Agreement Statute, ARS, Par 32-2151.02a, which requires that all real estate employment agreements be signed by all parties to the agreement and be written in clear and unambiguous language, fully set forth all material terms, including the terms of broker compensation, have a definite duration or expiration date, showing dates of inception and expiration. The court noted that the question of when an email communication qualifies as an electronic signature has generated significant discussion and diverging viewpoints. Thus, although the court held that the agreement is unenforceable without the broker's signature, the court remanded the case back to the trial court to determine whether the buyer's broker's thank you email qualified as an electronic signature of the agreement pursuant to the Electronic Transactions Act. ARS, Par 44-7001 et SEQ. The court acknowledged that the result in this case may appear harsh since the buyers signed the agreement. However, real estate brokers are presumed to know the law, and details matter. Reviewed May 2016. Although a real estate employment agreement is not required for a broker to represent a party in a transaction, most listing brokers have an employment agreement with the seller, and an increasing number of brokers have an employment agreement with the buyer. These employment agreements, commonly known as listing agreements and buyer-broker agreements, specify how and when a broker is paid a commission for services rendered. Therefore, it is important for brokers to understand the laws relating to real estate employment agreements. Requirements and prohibitions. Real estate employment agreements must comply with certain requirements. All real estate employment agreements must: 1. Be written in clear and unambiguous language. 2. Fully set forth all material terms, including the terms of broker compensation. 3. Have a definite duration or expiration date, showing dates of inception and expiration. And 4. Be signed by all parties to the agreement. ARS, Par 32-215102A. A real estate employment agreement is a personal services contract. As such, it is not assignable. Therefore, a broker may not assign an employment agreement to another broker without the express written consent of all parties to the agreement at the time of the assignment. See Olson v. Neal, 116 Ares Jivem 22, 570 P2D, 209, 1977, Listing Agreement. See also ARS, Paragraph 32, 2151.02b. Additionally, a broker is prohibited from attempting to procure a real estate employment agreement from a seller or buyer who is already subject to an existing exclusive real estate employment agreement, unless the broker obtains written acknowledgement from the seller or buyer that the execution of additional real estate employment agreements could expose the party to liability for substantial additional commissions. ARS, Par 32-2151.02c. Realtors may not enter into contractual relationships with sellers or buyers currently subject to an exclusive employment agreement, even if they do disclose the potential for two commissions. See Code of Ethics, Standard of Practice 16-14. Therefore, a broker should inquire whether the buyer or seller has signed an employment agreement with another broker before taking a listing or entering into a buyer-broker agreement. Listing agreements. A listing agreement establishes the duties of the broker and seller including the terms under which the broker will earn a commission. Generally, the seller's obligation to pay the real estate broker a commission, pursuant to a listing agreement, does not arise until the broker performs its obligation of presenting a ready, willing, and able buyer to purchase the property in accordance with the listing, or at some other price and terms agreeable to the seller during the term of the listing. However, actual payment of the commission generally does not occur until close of escrow. See J.D. Land Co. v. Killian, 158 Arizmar 210, 762 P2D 124, App 1988. If purchase contract was entered into before the expiration of the listing, a commission is owed even if the transaction closed after expiration of the listing. Although there are several types of listing agreements, the exclusive right to sell listing is the most common form. An exclusive right to sell listing agreement gives a single broker the exclusive right to sell the property for the specified period. An exclusive listing also gives the broker the right to a commission if a sale is made by another broker during the term of the listing. Galbraith v. Johnston, 92, Ayres 77, 373, P2D 587, 1962. Broker whose listing agreement entitled him to commission should land be sold within 1 year after expiration of listing to anyone with whom broker had negotiated was entitled to a commission without proving that he was procuring cause of sale. Additionally, a commission will be due if the seller unilaterally withdraws the property from market and sells it without the assistance of any broker. Larson Hegstrom and Associates, Inker vs. Jeffries, 145 Ayres 329, 701 P2D 587, Appier 1985. Seller obligated to pay brokerage commission under an exclusive listing of a shopping center after seller transferred the property to a church for $10 and other valuable considerations. Depending on the language used in an exclusive listing agreement, a seller may be obligated to pay the broker a commission if the property is transferred in any way during the term of the listing. But see Mealy v. Orlick, 120 Arizari 21, 585 P2D 1233, 1978. Taking by U.S. government was not a sale under listing agreement when listing agreement did not address condemnation. A broker is not entitled to a commission for locating a buyer during the term of the listing when the buyer does not enter into a contract with the seller until after the expiration of the listing, absent a provision specifying the terms of compensation after expiration. In Hyde Park Lake Park, Inc. vs. Tucson Realty and Trust Co., 18 Ayres App, 140, 500 P2D, 1128, App 1972. The broker and seller entered into an exclusive listing agreement that provided for payment of a commission in the event a sale was made within 90 days after expiration of the listing agreement to a party whose name had been submitted in writing to seller during term of agreement. The court held that this clause was enforceable. However, in Harold v. Grease, 115 Arizar 560, 566 P2D 1036, 1977, the court found that a broker was not entitled to a commission where buyer procured by the broker during the term of the listing purchased the property after the listing had expired, because the listing agreement had no provision for payment after expiration. Therefore, a broker should specifically address when a commission is due after expiration in all employment agreements. Buyer-broker agreements. A buyer-broker employment agreement is used when a buyer employs a broker to work with the buyer exclusively to locate property and negotiate terms acceptable to the buyer for the purchase of the property. Generally, by executing a buyer-broker agreement, the buyer agrees to work exclusively with the broker and to compensate the broker. However, oftentimes, the compensation the buyer is obligated to pay to the broker is offset by any compensation the broker receives from the listing agent or actually the seller. Prerequisites to an action to collect a commission. The statute of frauds states in pertinent part, "No action shall be brought in any court in the following cases unless the promise or agreement upon which the action is brought, or some memorandum thereof, is in writing and signed by the party to be charged, or by some person by him thereunto lawfully authorized. upon an agreement authorizing or employing an agent or broker to purchase or sell real property or mines for compensation or a commission. ARS, paragraph 44-1017. Thus, the statute of frauds prohibits a real estate broker from bringing an action for a commission without a written signed employment agreement that contains the terms and conditions of the commission agreement. McAllister v. Cooper, 91 Arizner 191, 370 P2D 767, 1962. Note: the statute of frauds does not extend to agreements between brokers to cooperate in making sales for a share of commissions. Nutter v. Bechtel, 6 Ares, App. 501, 433 P2D 993, 1967. In order to satisfy the statute of frauds, the agreement must show the fact of employment, the amount of the commission to be paid, and some description of the property. Nowell v. Andrew Wright enters, 143 Arizona 79, 691 P2D 1107, Appars 1984. Further, the specific amount of commission must be contained in the agreement. The going rate as a commission amount is too indefinite. Broadway Realty and Trust v. Gould, 136 Rs 236, 665 P2D 580, Appars 1983. Laws strictly enforced. These laws are designed to protect buyers and sellers against unfounded claims for a commission. Therefore, the requirements for broker employment agreements have been strictly enforced in Arizona.